Hello, Professor Coleman. How are you?
I'm fine today, thanks.
So how long have you been working for USF as an adjunct professor?
Since June of 2014, so about 5 years.
And what classes do you teach at USF?
Now I teach evidence, and I also do the externship supervision for criminal externships, both defense and prosecution. I've done that for a number of years. I also teach grand jury practice, and the longest class I've taught is ethical trial advocacy for prosecutors.
And of all those classes, which ones are your favorite?
They're all different. Some are seminars. The evidence class is a really big bar-required class. They each have their own pluses and minuses, but I like them all in the sense that the students are completely different in each class and the interactions are wonderful.
And you're also working at the SFDA's office.
I've been there 40 years as a prosecutor. I retired when I started up here, but I go back there 2 days a week as a consultant, and I work on Brady issues, grand jury issues, and whatever else they need me to work on.
And so, kind of going along on your article that you wrote for the Crawford Decision, can you maybe give us a little bit of background about the Crawford Decision and how it was an instrumental case in your opinion?
Okay. Well, I started in the DA's office in 1979, and in 1980, there was a U.S. Supreme Court opinion, the Roberts v. Ohio decision, which laid out a pretty clear rule for evidence in criminal trials, that if you could get over a hearsay objection with an exception to the hearsay rule that was a reliable, well-known, established hearsay objection, that you could get some evidence in. And for most of my criminal practice, for 25 of the first 40 years, we all followed Roberts. And prosecutors would look for an exception, and the defense would attack the fact that it was hearsay, and we get along. Then, in 2004, Justice Scalia, one of the more conservative members of the bench, came up with a whole new theory about evidence law and hearsay that involved the Confrontation Clause in the Sixth Amendment. And it involved evidence that would have otherwise been admitted. It was a key victim who gave a statement to police shortly after the crime, which would have been admissible as an excited utterance. The victim was no longer available to testify, but suddenly was not allowed to bring in that evidence to the prosecution because it violated the defendant's right to confront the key witness against him. And so what the Crawford decision did for the first time as a defense-friendly decision in only criminal cases and only when sought by the prosecution to admit this evidence, was to give the defense a whole new line of attack against evidence, not just hearsay, but does it violate confrontation rights? And it changed both sides' practice of criminal law. We now had to find a way to get around the Crawford decision by calling that witness either at the trial or at the prelim so as to have that witness be confronted by the defendant. We couldn't even go to the grand jury because there's no confrontation with the grand jury. And the defense had a new and novel and very powerful way to object to our evidence. So it really changed the practice of criminal law, and all the cases since Crawford and all the nuances of what Crawford meant that that whole area of law was in great flux for many years. It's only starting now to settle down. And as a law professor, what it made us do now is add a whole day to our evidence class just on Crawford.
And you kind of mentioned this, that both the defense and the prosecution had to change the way that they normally conduct cases where the witness is unavailable. Could you maybe tell us an example of how you had to kind of change your tactic, and maybe how the police too, when they are doing investigation, how they also have to kind of change their tactics, so to kind of if there is a chance where the declarant will be unavailable.
Okay, taking kind of that example of what happened in Crawford, where the key witness or key victim is given a police interview. Now, under Crawford, that is considered testimonial hearsay, because it's the kind of statement that an official of the state, the police, after the crime, when they're focusing on the defendant, are seeking testimony that could be used in court. With testimonial hearsay, the defendant has to have an opportunity to confront the witness. And the hearsay with an unavailable witness is simply not admissible anymore, unless there's that confrontation right. So if we have that kind of a victim who might become unavailable, we can't use her at the grand jury because she won't be cross-examined. We have to go to prelim, so it changes our tactic of approaching evidence. We have to call more witnesses at the prelim in order to preserve their testimony subject to cross-examination. Or we have to look for an alternative. Let's say that victim called 911. Well, cases after Crawford have said that when you're calling 911 to report a crime, that the dispatcher who takes your report is not developing testimony for a criminal case, but trying to give you comfort and figure out where to send the police. So that's admissible under the exception for excited utterance. If the victim were to talk to her neighbor or roommate or co-worker, that's not a state agent, so we can use that witness. So we have to encourage the police to get as many corroborating statements as they can, not just to rely on the victim, because if the victim's unavailable, we're stuck. Or if the defendant himself made an admission, that's not subject to Crawford because the defendant is at trial to, in a sense, confront himself as the declarant. So there's no hearsay or Sixth Amendment issue there. So we want to encourage the police to interview the defendant, give him his Miranda rights, and if they can get a statement, tell us the statement so we can use that. Even if the evidence is otherwise strong, give us as much evidence as we can use. We also have to deal with defense attorneys who are very vigorously fighting to keep evidence out. And one of the biggest problem areas in Crawford is a case that came after Crawford, Melendez, that talked about a crime expert working for the police, like a crime lab technician, who signs an affidavit saying, I weighed this white substance and it weighs 2 grams of cocaine, and it's positive for cocaine. That test analysis is testimonial hearsay prepared for a trial, and therefore we can't get it in under a business record exception. We have to have the actual analyst testify, if not at trial, at the prelim. And that changed our practice too, because we suddenly have to call all these analysts at every trial. We might anyway, but there's no way to get around that rule now.
I see. And kind of like a fun fact, so Scalia, in that opinion, in Crawford, he mentions Sir Walter Raleigh. I know that you have a fun fact about...
I do. When Scalia, who's known for his originalism analysis, going back to the founding fathers of the Constitution in our Republic, to find this rule, he went back earlier. He went back all the way to the early 17th century with the trial in England of Sir Walter Raleigh. Now, Raleigh was tried for a plot against the King of England, and he was convicted and sent to his death in the Tower of London based on 2 hearsay declarants. One was a Lord Cobham, who didn't testify at Raleigh's trial. A magistrate, a subject working for the Crown, took his statement and then read the statement to the trial. So there was no chance for Walter Raleigh to confront Lord Cobham. And even worse, there was the testimony of a ship's pilot in England, the master of a ship who guides them into a harbor, who had taken an English ship at some point to Lisbon, and then talked to a Portuguese gentleman, we don't know his name, who stated to this ship's pilot that Cobham and Raleigh were plotting against the king. And that hearsay testimony of the Portuguese gentleman came in, and there was no chance for poor Sir Walter Raleigh to cross-examine the gentleman. All he had was the ship's pilot. So going all the way back to that trial, and the excesses of the Crown's evidence in that trial led Scalia to come to his confrontation right rule. But the fun fact is that even after the conviction, and he was in the Tower of London awaiting execution, the Crown needed Sir Walter Raleigh, who was one of their best seamen, to lead an expedition to the new land, the new world, North America. And so they let him out to do this expedition, and then when he came back, then they executed him.
Well, thank you so much, Professor Coleman, for writing the article, and please check out Professor Coleman's article on the forum. Thank you.